Our previous discussion ends with types of directors, if I am not wrong, right? But we are unable to complete the whole discussion. In types of directors, somewhere around 5 to 6 types of directors we have already discussed. I think somewhere around nominee director, alternate director, additional director. So before we will jump into the session, let's quickly revise what we have discussed so far. First of all, we discussed about 234, section 2, subsection 34. What it says? Director definition. Director is a person who is appointed to the board. And next, role and importance of director. There are 5 concepts or 5 points simply. Fiduciary position, compliance officer, strategic planner, decision maker, legal representative. After that, minimum number, maximum number. 1, 2, 3. 1 for OPC, 2 for private company, 3 for public company. And maximum 15 in general. We can appoint way more than 15 also by simply passing a special resolution. But passing the special resolution point will not be applicable to 2 companies. One is Section 8 company, another one is government company. I hope you all know what is meant by government company. Central government or state government or collectively central and state government holding not less than 51%. Clear. Next one, types of directors. So in types of directors, this is minimum number and maximum number. Types of directors. Just a minute. Yeah. In types of directors, we completed this one, executive director. Who is an executive director? Who will actively engages in the day-to-day affairs and administration of the management of the company. Second one is non-executive director. So non-executive director will not participate in the day-to-day affairs. He will participate in the decision-making meetings, policy-making meetings, kind of strategic meetings, etc. MD and WTD. Can a company have multiple whole-time directors? Multiple managing directors? Multiple managing directors are having multiple managing directors for a single company is not allowed as per Companies Act. If you wish to spread it, you can spread it in the name of joint managing directors. CEO and MD parallelly allowed? No. Okay. So what is the major difference between MD and WTD? Powers. MD is entrusted with substantial powers, but whole-time director will not be having substantial powers. He will be having limited powers. Okay. Next one, independent director, we have already discussed. Who remembers the limits of independent director? For a listed company, there are no limits. If it is a listed company, it must have 1/3 of total strength of directors as independent directors. If it is an unlisted public company, we should check threshold limits. There are 3 threshold limits. One is paid up share capital, second one is turnover, third one is outstanding deposits, loans, debentures, etc. etc. Limits are 10, 100, 50. Cumulative condition or any one of the conditions satisfied? If the company satisfies any of the above 3 mentioned conditions, it must have independent directors on the board. Minimum number of independent directors for a unlisted public company is 2. If you wish to have more number of independent directors, you can do so. It is upon to you. Independent directors provisions not applicable to private company, but having independent directors is a crime. Having independent directors is a crime. It is for the corporate governance, according to corporate governance measures, I will discuss in module number 3. Having independent directors is a welcoming step. It is for the good and bona fide benefit of the stakeholders as well as shareholders. That is why if a private company wishes to have independent directors on their board, it is a welcoming step, most welcome. Okay, but the provisions are not applicable to private company. But if it wishes to have independent directors in its board, it can do so happily. And the third one, and the next one, nominee director. I have already discussed. Who is a nominee director? Nominee director is a director nominated by third parties or outsiders or external parties, generally financial institutes like banking companies, NBFCs, or governments. Okay, next one. Nominated director will work according to the interests of nominated party, not according to the interest of the company. Okay, next one. Alternative director and additional director. We will appoint alternate director in the place of original director only if the original director is out of India for a minimum period of 3 months. Next one, additional director. It is additional director will be appointed purely to discharge the workload. That is why additional director will be appointed by board of directors but not by members in the general meeting. Additional director will be appointed by whom? Board of directors, not by general meeting by the shareholders. Okay. Next one, casual week. One more thing. In order to appoint additional director, there is an eligibility criteria. What is that eligibility criteria means? Whoever disqualified or whoever failed to appoint as a director in the general meeting will not be allowed to act as additional director. Let's take a quick example. You please stand up, first 3 members. Stand up. So these are the 3, you also, two members. So these are the 5 members. They submitted the candidature to the company to act as directors. So how many members are there? For example, you guys are members of a company. You came here to appoint directors to the company. So what is your role and responsibility for today's session? You have to appoint board of directors to your company to run the company in a successful way. Okay, following. So how many candidates are applied to act as directors? 5 members are applied for the candidature. But you don't like this person. And you don't like that person also. Sit down. You successfully elected these 3 persons as directors. You simply rejected these 2 persons' candidature to act as directors due to some personal reasons or whatever the reasons you are subsisting with them. Okay, so you don't like these 2 persons. You appointed the 3 members as directors to run the company. Okay, general meeting has been successfully convened and closed. You went away. Company is running. After 1 month, all these 5 members are actually friends. So now what these 3 board of directors are doing is they indirectly taking these 2 members as additional directors. It means in first step they try to enter into the company. That rejected person, you guys sit down. Rejected persons get up. These 2 persons are rejected by the members of the company, saying that these 2 persons are not allowed to act as directors. Okay. Now what they are doing is they are entering into the company from back door in the name of additional directors, because additional directors appointing authority lies with board of directors, not with members. So these 3 board of directors are actually friends of these 2 persons, right? That is why they are doing the favor to the old friend, saying that these 2 persons will act as additional directors of the company. It means the 2 persons who are actually rejected by the shareholders in the general meeting, they are entering into the company successfully through the back door. Okay, so is it allowed? Say for example, if these 2 persons are actually qualified to act as directors, why you guys reject? Are you foolish persons or not? So if you wish to appoint these 2 persons, you might have actually appointed as directors in the general meeting itself. So these 3 directors are making all the shareholders as bunch of fools. That is why in order to appoint additional director, everyone is allowed, but those persons who rejected by the shareholders in the general meeting are not allowed. It means, are you allowed to act as additional director? Yes. Are you allowed? Are you allowed? Everyone is allowed except these two persons. Why you guys are not allowed to act as additional directors? Why? Because you are rejected by the members in general meeting. Your candidature has been rejected by the members due to various reasons. So that is why everyone is allowed except these two persons. Are we clear? Sit down. So this is an important point. They might ask it the same concept in a practical scenario or a case law scenario. Okay. Next one. Are we clear with so far discussion? Everyone is following? Next one is CVD, Casual Vacancy Director. I have already discussed this thing also. Casual vacancy means vacancy in the position of a director who originally appointed by the members of the company in general meeting. Say for example, I am a board of director. I appointed an additional director. Appointed an additional director for a period of 1 year. After completion of 3 months only, he left due to his personal reasons. Now, this vacancy is will not be called as casual vacancy. Why? Because who is the appointing authority? Additional director is appointed by me. So I am a board of director. So vacancy in the position of a director who is appointed by board of directors will not be termed as casual vacancy. The definition of casual vacancy means vacancy in the position of a director who originally appointed by shareholders in the general meeting. That vacancy will only be called as casual vacancy. That vacancy will only be called as casual vacancy. So, casual vacancy directorship. In case of casual vacancy director, in the concept of casual vacancy director, actually the vacancy should be filled up by whom? Actually, the vacancy should be filled up by shareholders in the general meeting. Why? Because who is the actual appointing authority? Members or shareholders. So who should fill that vacancy? Again, shareholders. But in order to just fill one vacant position in directorship, convening a general meeting, it might be practically difficult task. That is why the power has been transferred from shareholders to board of directors. So now who fills the vacant position of CVD? Board of directors. Actually, it should be filled by shareholders, but is actually been filling by board of directors. You got the clarity regarding the concept, right? Yes or no? Next one, RD, resident director. Is the discussion regarding RD completed or not? No. Very good. So let's quickly understand what is the concept of RD, resident director. Students, remember only one thing. Resident directorship got no relevance with citizenship. Resident means greater than or equal to 182 days in a financial year. Simply only follow this thing, only one rule. It has no relevance with citizenship. Examiner will try to confuse you by giving, say for example, he frames one question. Say for example, Mr. X is a Irish citizen or UK citizen, British citizen. He came to India recently and staying in India from past 190 days. He has no citizenship with India. He is a British citizen. Now, company wish to appoint this Mr. X as resident director. Is he allowed or not? Is he allowed or not? Is he eligible to appoint as resident director or not? Being I just spoke the concept, you are all confidently saying, yes, he is allowed to act as director. But after few days, if you forgot the concept, then everybody, 95% of the people say, no, how he will be allowed to act as resident director? He's not an Indian citizen, he is a British citizen. Not allowed. Remember, in order to act as resident director, what is relevant, what is the relevant point or what is the eligibility requirement is only staying 182 days or more in a given financial year. That is the only relevant point, nothing other than that. He might be an Indian citizen or he might be a foreign citizen also. And one more thing, resident director concept is applicable to each and every company, whether it may be OPC, whether it may be private company or it may be public company, listed, unlisted, whatever it may be. Having resident director is mandatory for each and every company who incorporated as per Companies Act 2013. Sir, in case of OPC, only one director is the minimum requirement, right, sir? That one director must be resident director. That one director must be resident director. Okay. So, who is a resident director? Who stays in India for more than or equal to 182 days in a previous financial year. Citizenship has nowhere relevance with the eligibility to appoint as resident director. So both are entirely different. What is only relevant, what is the actual relevant point is staying. Period of staying is the only relevant point. And next one is women director. You all know. Recently held June 2025 examination also, he asked an MCQ regarding women directorship. Nominee director, additional casual vacancy completed. Resident director. Let's quickly read out the resident director topic. Yes. Every company, what is this point? Must means compulsory. Must have at least one director who has stayed in India for at least 182 days in the financial year. Applies to all the companies including OPC. This applies to all companies, private, public, listed, unlisted. Even a foreign national can be a resident director if they meet the stay requirement. Okay, so that is the point. Next, women director. This is the criteria. If it is a listed company, having women director is mandatory thing. If you are an unlisted public company, these are the threshold limits. Only two threshold limits. One is paid up share capital requirement, 100 crore or more, and another one is turnover requirement, 300 crore or more. Sir, will these two conditions will be cumulatively satisfied or satisfy any one of the condition attracts these provisions? Means if a company satisfies any one of the given provisions or given threshold limits, it will attract with the provisions of women director. So whether it may be turnover limit or it may be paid up share capital limit. Paid up share capital limit how much? 100 crores. Turnover 300 crores. Having women director in your board of directors is mandatory if these provisions are attracted. She may be executive director, non-executive director, independent director, managing director, additional director, alternate director, whatever it may be. It is a naam ke vaste provision. Okay. There is no relevance with the managerial ability or something skill set, etc. Only if she is a woman, you should appoint if the threshold limits or the given limits are given provisions are attracted. That's it. Okay. So points, must be a woman. Obviously, woman director must be a woman. Next one, no specific qualifications beyond general director qualifications. So if she is capable to appoint as a director, sir, what are the qualifications of director? That is our next discussion. Qualifications and disqualifications. See, what is the heading? Qualifications and disqualifications. I am going to tell you there. Okay. Next one, the appointment should be made within 6 months of falling under the criteria. So this 6 months time is called buffer time. Say for example, in previous financial year, my paid up share capital is, I am an unlisted public company. I am a unlisted public company. Having women director is not mandatory for me unless and until I will satisfy the given threshold limits. My paid up share capital is 90 crore and my turnover is 290 crore. Applicable or not applicable? Not applicable. These are the limits, these are the numbers of previous financial year. Now, in this financial year, my turnover 310 crore, paid up share capital same 90 crore. After completion of this financial year, I will be attracted with these provisions. Now, I will be provided with 6 months buffer time to search a woman and appoint that woman into my board. Okay, this is the 6 months buffer time is the required, complaints requirement or complaints buffer time requirement or not. So 6 months time. Next one, she can be executive director, non-executive director, independent director, whoever it may be. Next, small shareholder director. This is the last concept of types of directors. So small shareholder director means it is not a mandatory thing. Having small shareholder director is not at all mandatory as per Companies Act 2013. When you should appoint SSD means if there is a requisition from your members, if there is a demand from your members. Sir, I have 10,000 shareholders, sir. One of the shareholder made a demand to appoint small shareholder director. So should I appoint? No. There is a mathematical calculation. That what is that mathematical calculation means? It should be demanded by 1,000 small shareholders or 10% of small shareholders. See, mandatory in case of listed company if not a plain requirement mandatory for listed company. No, mandatory for listed company if it has been required made a demand by 1,000 small shareholders or 10%, 1 by 10 or 10%, both are same, right? So 1 by 10th of total number of shareholders. Students, listen carefully. Total number of shareholders means not all shareholders, only small shareholders. Say for example, who is a small shareholder who is having nominal shares of 20,000 or less or below. So say for example, I am holding 100 shares. The nominal value means you all know, right? Face value. The face value of each share is 100 rupee. 100 into 100 how much? 10,000. So I am holding shares worth of face value 10,000. Whether I will be qualified as small shareholder means yes, I am a small shareholder. So the demand should be made by persons like me. So how many persons should make this kind of demand? Either 1,000 shareholders or 110. That means 10% of small shareholder, whichever is less. I'll give you a simple example. You will get the conceptual clarity. Say for example, there is a company called X Limited. Total number of shareholders. I am talking about shareholders. Total number of shareholders in this company is 15,000. Persons who are holding face value of shares 20,000 or less are around 12,000. So these 12,000 members are called as small shareholders. So according to the small shareholder director provision, the requisition or the demand should be made by 1,000 small shareholders or 10% of small shareholders. Who is the how much is the small shareholder number? 12,000. Out of 10% means 1,200. 1,000 or 1,200, whichever is less. So the demand should be made by 1,000 small shareholders to the management. Then having small shareholder director is mandatory for the company. If there is no demand, no small shareholder director. If there is no proper demand, say for example, 1,000 members are not there as well as small shareholder collectively made a demand, but the percentage came up to only 5% or 2% or 3%. Threshold limits are not satisfied. Then also no requirement to appoint small shareholder director to your company. And one more thing, small shareholder director will work according to the interest of small shareholders only, but not according to the interest of the company. We recently studied a topic like this. What is that concept? Excellent. Nominee director. In the same way, small shareholder director also will act according to the interests of small shareholder, but not to the according to the interest of company. And the beautiful point is, small shareholder director's tenure is only max 3 years. Maximum 3 years. After completion of 3 years, he is not eligible to reappointment. So cooling period is applicable. Again, the cooling period is 3 years. Again, the cooling period is 3 years. So listen carefully. What is the tenure of small shareholder director? 3 years. After 3 years, is he eligible for the reappointment? No. Yesterday, we studied a topic like this in independent directors. What is the original tenure of independent directors? Maximum 5 years. After completion of 5 years, he again eligible to act as independent director for the same company for another 5 years. But the provisions are not like this, not like the independent provisions in small shareholder director. As and when the original tenure of 3 years completed, he should vacate the office. The cooling period provisions will be applicable. And how much is the cooling period? Again 3 years. And the difficult point is, and the not difficult, but crucial point is, examiner will try to test you in this provision, in this rule. Maximum a person can hold only up to 2 small shareholder directorships parallelly. Maximum a person should hold maximum 2 small shareholder directorships. I have already told you regarding maximum number of directorships, that is 20. Out of this 20, maximum sublimit is there. 10 must be public companies and another 10 must be private companies. Oh, not must be, maybe. So 10 public companies, 10 private companies. Say for example, sir, I'm a director in 9 public companies and 11 private companies. Is it allowed? Yes. 8 public companies, 12 private companies. 11 public companies and 9 private companies. The sublimit is maximum 10 public companies, right? This is the number of directorships, actually 20. Out of this 20, maximum 2 SSDs are allowed. Small shareholder directorships, maximum a person can act as small shareholder director parallelly in only maximum 2 companies. Say for example, I am a small shareholder director in X Limited. Again, shareholders of Y Limited appointed me as a small shareholder director in order to protect their interests. Yes, eligible. Now, Z Limited shareholders are also came to my house saying that they are saying that they are proposing my candidature to Z Limited to appoint as small shareholders director. Am I eligible to act as small shareholder director in Z Limited also? I am a small shareholder director in X Limited. I am a small shareholder director in Y Limited. Parallelly, I am acting as small shareholder director in 2 companies. Again, no candidature. I am not allowed to act as small shareholder director in 3rd and subsequent companies. Maximum I can hold small shareholder directorships in only 2 companies. These are the crucial points in SSD. Let's quickly read out. Yeah, applicability. First point. Just a minute. Yeah, applicability. First point. Mandatory in case of listed company if 1000 small shareholders or 1/10 of the total number of shareholders, whichever is lower. Whichever is. Students, write down total. All you have material, right? So total number of shareholders. Underline this point and write the total number of shareholders here means small shareholders. At revision time, you will definitely confuse with the provision. Here, total number of shareholder means what kind of shareholders? Only small shareholders. We have already seen a practical example, right? Total number of shareholders in the company 15,000. Total number of small shareholder 12,000. So in order to calculate 10 percentage, 1500 will be taken or 12,000 will be taken? 12,000 will be taken. I have a small doubt. Who is a small shareholder? Nominal value or market value? Small shareholder calculation will always be depend on face value, that is nominal value, but not depending on market value. If I am holding shares worth of having face value worth of 20,000 or less, then I will be considered as a small shareholder, and the request must be done by at least 1000 members or 10% of total strength of small shareholder, whichever is lower. Then board of directors will consider regarding the appointment of small shareholder director. Clear? Next one. So mandatory in case of listed company, if 1000 small shareholder or 10% of total number of shareholders, whichever is lower, give a notice to the company. So they should request the company, sir, we need our representation in the board. We need to actively participate in the management and affairs of the company. Of course, we are holding less number of shares, but we wish to know what is actually going on in the company. We need our representative. That is why we wish to have one person in your board. So that is why we are giving representation to you to appoint Mr. Subbarao, Pullarao, Apparao as a small shareholder director in order to represent our interests in the board. Okay, so that is the candidature. Next one, voluntary for any company if it chooses to appoint such director. Say for example, you wish to do a good thing, will Companies Act will oppose you? No, you are not allowed to do such good things. Actually, even though the provisions are not applicable to you, you wish to comply the provisions. Happily comply. Who stops you? Next one, how SSD is appointed. I have already spoke regarding this. First of all, eligible shareholders, eligible members must give a candidature or a notice to the company, and they should sign. Why? Because as the giving persons are really small shareholders or not, company should know na. That is why their name, address, number of shares holding, folio number or DPID or client ID. Folio number means, have you ever seen the physical share certificate copy? In share certificate copy, in good olden days, they used to give shares in certificate form, physical form. In physical form, they used to have numbers. That is folio number. But nowadays, shares are not coming with numbers. They are coming with DPID. DPID means whenever you are having a demat account, DP means depository participant. There are only two depository participants in India: NSDL, CDSL. NSDL, CDSL. So DPID in electronic form you should submit on matter. Next one, signatures of the shareholders proposing the persons. These eligible persons should give a representation to the company regarding the appointment of small shareholder director. Then the company will try to appoint small shareholder director in general meeting through ordinary resolution. Through ordinary resolution. What is that underlined line? It means who will appoint the small shareholder director? Shareholders or board of directors? Say for example, small shareholder director, after appointment 3 months has been passed and small shareholder died. What is this concept will be called as? This vacancy will be called as casual. Who will fill this casual vacancy? No, small shareholder director will be appointed by small shareholder, right? Why board of directors are appointing? Because in case of casual vacancy, the vacancy will be filled by board of directors. Clear? Next one. The eligibility criteria. First one, it is a common point. He should not be disqualified to act as director according to section 164. Actually, in section 164, there are 3 sub-provisions: 164.1, 164.2, 164.3. 164 talks about disqualifications of a director. It is a very, very, very important thing. There is a bright chance of minimum 60 to 70% chance of getting the question from disqualifications of director from each and every attempt. In each and every attempt, there is a possibility, not a surety. There is a possibility. How much possibility? 60 to 70% possibility that you might encounter a question from the concept of section 164. That is a very beautiful section. Why? Because students tend to confuse in section 164. 3 types of disqualifications will be there. Personal disqualification, company level disqualification, article level disqualification. 164.1, 164.2, 164.3. If time permits, I am planning to discuss 164, but I hope time is not sufficient. Next one, after eligibility, eligibility, first one, the person should not be disqualified as per section 164. And the second one, not hold directorship in more than 2 companies where he is a SSD, small shareholder director. I have already explained this provision. Second provision, everybody understood or not? Next one, not be a retiring director under section 152. Not be a retiring director under section 152. Why? Because read the below provision, you will be came to understand the above provision. One last point is not be associated with the company or its promoters in any professional capacity in the last 3 years. Say for example, he is saying that you should not be associated with the company from last 3 years. Last 3 years. Say for example, I am a director who is working in the company and I am going to retire now. Am I eligible to act as small shareholder director? Day before today itself, I am working as a director in the company. Just now I retired. That means I am associated with the company or not? What this provision is saying, the person should not be associated in any professional capacity from last 3 years. Then how am I eligible to act as small shareholder director? Because being I am associated with the company, I am not allowed to act as small shareholder director. Clear? Next one. Why this provision has been made? I have already told that small shareholder director should represent. He will not work according to the interest of company. He should work according to the interest of, say for example, if this provision is not there in the act, what people will do? They will appoint a biased person in the place of small shareholder director, and he will work according to the interest of company, not according to the interest of. Then what is the point of having small shareholder director? That is why this provision has been designed. Everybody following? So with this, we have successfully completed the explanation regarding the types of directors. Okay. So tenure and all I have already explained, right? What is the tenure? 3 years. After that, he is eligible to reappointment, right? He will not be eligible for the reappointment. Cooling period provisions will be applicable, and the cooling period is 3 years. Let's quickly write down. Cooling period means 3 years. Actually, I forgot to give in the material. Write down. Only after a cooling period I have written, but cooling period how much? 3 years. Write down in your material. Next one, roles and powers. Small shareholder director is treated at par with the other directors. At par means same. Very good. Equal. At par means same. So small shareholder director have each and every power what the other director or general directors is having. Next one, he can be independent director if he meets the criteria and not required to be elected by rotation. Why rotation provision is not applicable? He is coming into the company with a fixed tenure. He is coming into the company with a fixed tenure. What is the fixed tenure? 3 years. Then why again reappointment rotation is required? So in case of rotation calculation also, we will exclude this person. We will exclude 3 persons in case of rotation. What are those 3? Who are those 3 persons? Means small shareholder director, independent director, nominee director. Simple. So this is the summary table of what we have already discussed so far. This is the summary table. What is the summary table? First point is executive director means full-time involved in daily management. Second one is non-executive director, part-time advisory role. Full-time or part-time? Part-time. Next one, managing director. Section 254 is saying that he is entrusted with the substantial management power. Whole-time director devotes whole time to the company affairs. But he might not be having substantial powers. He is having limited powers. Independent director, independent of company and promoters. Yesterday we have read out the provisions regarding independent director. He should not be having any material or pecuniary relationship with the company, management or promoters. Next one, nominee director, nominated by institutions or government. Alternate director, substitutes for an absent director. That absence must be greater than or equal to 3 months. Next one, additional director. Additional director means appointed by board until next AGM in order to discharge the workload. Next one, casual vacancy director, appointed to fill midterm vacancy. What is midterm vacancy? Vacancy before the original term. Vacancy before the, say for example, a director has been appointed for 1 year. After 6 months, vacancy arises. This is called midterm vacancy. Clear? Next one, resident director. Resident director mandatory or not? Resident director mandatory or not? For each and every class of companies, having a resident director is mandatory. Can a foreign national be appointed as a resident director? He may be an Indian citizen or he may not be an Indian citizen or British citizen, UK, US citizen, whoever he may be or she may be. What is the requirement? What is the requirement is he should stay in India for a period of more than or equal to. Women director, section 149 is saying mandatory for certain companies. What are those certain companies? Listed company mandatory. Unlisted public company, we should check 2 terms, 2 threshold limits. What are those 3? What are those 2 threshold limits? Paid up share capital 100 crore or more, turnover 300 crore or more. Very good. So with this we have another thing, small shareholder director is there, but not that much important. That is why I am not included in the summary table. So this is all about the discussion regarding the types of directors. Types of directors. Are we clear so far? First of all, directors we came to know, roles and powers, minimum number, maximum number, types of directors. Okay, I have already told that directors and KMP, board meetings and procedures, these 2 topics carries around 50% of the weightage of Companies Act. Say for example, if Companies Act is coming for 30 marks in your examination paper, these 2 chapters only comprise of 15 marks. There is a possibility, not a guarantee thing. There is a possibility. These are the 2 crucial things and vast things. Content wise also, these 2 topics occupy vast weightage and vast content also. Say for example, if you already studied about index, last 3 topics are there: inquiry, inspection, inquiry, investigation, compromise, arrangement, amalgamation, prevention of oppression and mismanagement. I'll complete these 3 topics in 3 days, 3 sessions. If a session is about 4 to 5 hours, I'll complete in 1 day. Why? Because not that much discussion is required for those 3 topics. So don't think about syllabus completion date and syllabus completion hour. Sir is going slow in this way. If we go in this way, how many days it will take to complete our syllabus? In first session also, I have clearly spoken about completion date as well as completion hours also. How many hours? 100 to 120. 100 is for concept maximum. Another 120 is for MCQ discussion and buffer sessions. In 120 hours, we are going to complete our entire syllabus in a comfortable way. And the date wise, what is the deadline? August 31st, definitely we are going to complete our syllabus. So don't think about all these things. So what you need to do is come to sessions regularly, attend the sessions regularly. So coming to the session and attending the session, both are different. Coming means physically coming, body present. Some students are there, body present, mind absent. They'll just come and sit like that. They will not participate in the discussion. Actually, at CMA final level, examiner will demand analysis skill from you. Just listening the classes is not enough. Listening the classes is enough for foundation and inter-level. At final level, examiner will demand analyzing skill from you. For example, there is a provision. The plain provision will not be asked by the examiner in CMA final question paper. He will frame a case law according to the provision, or he will frame a practical question. If you clearly know about the in and out provision, then only you will be able to understand that question and answer that question. That is why I am explaining each and provision in detailed manner. You all know, you all read about Section 8 company in Inter. Asked a simple question in the first session. Is Section 8 company is a public company or a private company? How many of you are able to answer that question properly? That is analyzing skill. In final level, analyzing skill will appear only through your participation. If you are idle and will not participate in the discussion, will not give value addition to you in the examination. You will suffer in the examination. You have to know provision in and out, 360 degrees you have to analyze. Another simple thing, yesterday we spoke about a complicated provision like independent director. In case of independent director, appointment will be done by board and approval will be given by shareholder. Everyone will read this provision like this and forget. But in case of reappointment of an independent director, which resolution is required? People are looking here and there for the answer. Board resolution. Initially, board appointment will be done by board only, but the approval will be done by members, na? Members. For reappointment, which resolution is required? Excellent, excellent. Anil, special resolution. I have already told you in the previous classes. Yesterday's class, not previous class. Listen carefully, at least now. This is a difficult provision, ma. These kind of questions will ask in the same final level. What are you expecting? Write about private company. Who is a minimum number, maximum? May be important. They will come in MCQs. But in 7 marks questions, sub questions, they will demand analysis skill from you. Again, I am saying, listen carefully. ID means idli dosa batter. Independent director. Independent director tenure is how much? 5 years. After 5 years, what we need to do? He may be eligible for the, if he is eligible, if he is qualified, we will reappoint. So maximum how many further more years? 5 plus 5? 10 years. So after completion of 10 years, cooling period will be applicable. He is not allowed to reappointment again, third time. Okay. At this point, I have clearly told a simple provision like, so for appointment of independent director, the initial appointment will be done by board of directors. And after the appointment, the board will seek the approval from members in general meeting. Next general meeting or the meeting which is going to be held in coming 3 months, whichever is later. So the members, the board of directors will seek the approval from members, and the members will approve the appointment of independent director through ordinary resolution. Ordinary resolution. Say for example, which resolution is required for the appointment of board of director? Ordinary resolution. In the same way, for the appointment of independent director also, ordinary resolution from the members is required. The initial appointment will be done by board of directors. But after that, the same approval regarding the appointment should be coming from, should come from members in the general meeting through which resolution? Ordinary resolution. This is the first case. But for the reappointment of the same director as independent director, again BOD will appoint for the in the second tenure, but for the members thing in the general meeting, the members should pass special resolution. Ordinary resolution is not at all sufficient for the reappointment of independent directors. This is the complicated provision. In general, students listen carefully. In general, which resolution from members is required to appoint any director, not independent director, any director? Generally, the directors of a company will be appointed by passing a ordinary resolution in the general meeting. This is the general rule. Keep this point in your mind. This is the general rule. Which resolution is required? In which meeting? General meeting. In general meeting means who will participate? Shareholders will participate. This is the general rule. In the same way, for the appointment also, for the appointment of independent director also, ordinary resolution is required from members. For appointment, I am saying. For appointment. But for the reappointment means first tenure or second tenure? Second tenure. But for second tenure, ordinary resolution from members is not at all sufficient. Which resolution is required? Special resolution is required. This is the in-depth provisions which 99% of the students will not cover, and examiner will frame a practical question and ask for 7 marks. And students will come out of exam hall and saying that paper is very tough. Okay, so I have already told you that if you attend this 120 or 100-hour session, it is more than enough for you to score good marks in paper number 13. In first session only, I have clearly communicated to all of you what must be the target in paper 13. 40 or 45? 50. Minimum target I have clearly wrote. Minimum target, not average target or maximum target. Minimum target for each and everyone must be 60 plus. If you attend the sessions regularly, July and August, you are going to score minimum 60 plus. This is my word. You have to follow the materials blindly. You have to follow the classes blindly. Just 2 months, enough. Paper number 13 is going to act as a catalyst for your entire group 3. Even though you score bare minimum marks in other subjects, paper number 14, 15, 16, 40, 40, 45 average you score, you are going to score excellent marks in paper number 13. Why? Because there is a scope. I am not degrading other papers. I am saying that it will be act as a catalyst to qualify entire group 3. So even though for some people, some subjects might be, they will feel those subjects might be difficult to understand. They'll score bare minimum marks, 40, 45. Concentrate on paper 13. There is a good chance for scoring 60 plus easily. That is why this paper is a catalyst. That is why coaching is required for paper number 13. Usually, you are all having board books, right? SFM book will be like this. DT will book like this. SCM, DM like this. Corporate and economic class book is, it is a slim book. By watching the book, by observing the book, many students think that we can study this subject on our own. They'll face the difficulty in exam hall. Why? Because law, Bayer Act also, even 10 pages of Bayer Act, it contains enormous amounts of knowledge and exceptions. Have you ever read Bayer Act? Bayer Act. Hardly Indian Contract Act, Bayer Act comprises of hardly 20 to 25 pages. Free consent chapter is there, free consent, consideration, offer and acceptance chapters are there. Hardly it will occupy 8 to 9 lines, that's it. But In order to understand that 8 to 9 lines of bare act, we have to design 30 to 40 pages of material. That is the power of bare act. Actually, in your books also, in brief, he has explained. But in order to that acts in a understandable manner, we need coaching and we need guidance. Then you will face, definitely you will feel happy in examination hall. That is our entire motto. Okay. So coming to the original topics, time is around 8:20. What we left with only qualifications and disqualifications. Qualifications and disqualifications. Okay, we'll try to cover this qualifications and disqualifications tomorrow. Okay, 8:20 time is all. 9 to 1 entire full session, or is there any break? Ideal time is not there for entire, your whole day is occupied. What is your schedule? 9 to 1. After that? Okay, nothing to comment about it. Okay.